My Lord, my Lady. I was dealing with, and just want to finish off, some of the background to and the context of the introduction of Section 4. I've taken you briefly to the Better Regulation Task Force report. I just want to take you to the reference to that in the explanatory notes, which is on page 595. And at paragraph 28, the Better Regulation Task Force report, Better Routes to Redress, published in May 2004, found that compensation culture is a myth. It's a damaging myth. It identified the activities of claims intermediaries as contributing to a have-a-go culture. Then sets out at paragraph 29 some of the concerns. That whilst there were established complaints mechanisms and bodies to help people who are unhappy with the way they've been treated by solicitors or insurers, there's been no clear-cut equivalent in the case of claims intermediaries. Mr. Thankey took you to the other paragraphs that I would have drawn attention to, but I won't do it again, which were paragraphs 31, 34, and 35 on that page and on the following page. If I can then take you to the explanatory memorandum.
Sorry, before we move on from this, what do we get out of this in terms of assisting with the interpretation of the 2006?
What the report was looking at and what the mischief was aimed at was claims intermediaries and those who were carrying out the characteristic activities of a claims management company. The latter part you're going to get from the explanatory memorandum to the almost contemporaneous scope order.
But, well, are you going to address the argument that legislation may be framed with a particular target in mind, but with a consciousness that the legislator wants to be sure that they're catching all variants of that particular form of practice, even as it may develop, and so they may deliberately set the parameters wide?
Well, we accept that, well, we would submit that even on the divisional court's interpretation, the parameters are still wide. And the scope order, for instance, that you were taken to, the matters that are regulated there and become regulated claims management services, would all be covered, we say, by the definition given in any event, or the interpretation given by the divisional court. We would say that Parliament can't have intended to provide such a wide power that it would or could lead to absurd consequences whereby activities that are outside what would ever be recognised as claims management services could be caught. So, for example, it's important to note that so far as Section 4 is concerned, Section 4.2e, when it comes to which services are to be regulated, has the word "or" in it. So the Secretary...
It's not ridiculous to postulate that Parliament might want to regulate litigation funders, is it? I mean, they have a voluntary code of conduct at the moment, but if that wasn't proving sufficient, the sort of rules in that, it might be thought appropriate to put in legislation.
Of course I have to accept that it's not absurd to suggest that Parliament might want to regulate third-party funders. But what we submit is that third-party funding is not something that could ever be characteristically described as claims management services, to use the word that's used in the explanatory memorandum.
Well, that might be so if it was just left at large, but It wasn't. That's the problem you had.
As I say, our submission would be that Parliament kind of intended to have provided a power that if it was exercised pursuant to Section 4(2)(e),
which is on page, what, sorry, again?
I do apologise, 591. So services are regulated if they are of a kind prescribed by order of the Secretary of State or provided in cases or circumstances of a kind prescribed by order of the Secretary of State. So if the Secretary of State had just gone for, which he or she clearly could, 4(2)(e) and said, right, well, all claims in relation to, let's say, PPI, to use an obvious example of those of us who've probably had calls from claims management companies. So it could say all claims in relation to PPI, or it could say all personal injury claims. Then within that, one would have the sort of absurd, or we would suggest, absurd services that are referred to in our written case about the person who, the solicitors who want to issue a claim, they need to get it translated because in order for the statement of truth to be signed, it couldn't be issued without that translation. Is therefore that intended to cover the translator? Is it intended to cover the process server? Is it intended to cover Legastat? Is it intended to cover all those examples, some of which clearly one might say, well, aren't sufficiently connected? But all those examples would nevertheless be services that have been provided in relation to the making of the claim. And without those services having been provided, the claim could not have proceeded.
So what do you deduce from that?
I deduce from that that would be that would only fall within the definition if the definition is indeed as wide as suggested on behalf of DAF, and has no limit. Whereas we say it has to be limited.
Well, we're not concerned with the people who provide photocopying, we're concerned with third-party funders. Why wouldn't they have been intended to be within the scope of potential regulation?
Our submission is that independent third-party funders are not involved in the management or control of a claim. They fund the claim. If a third-party funder is to be captured, then so would, subject to any exemptions that the Secretary of State might provide, so would the bank that is approached and said, I need £5,000 to pay these new court fees. You can have a charge over my home. The bank would be caught. So would MasterCard or any other card provider who provides a service to enable you to pay the court fees. So
I think it's common ground that actually third-party standalone funding was not established in 2006.
Well, I'm grateful, my lady, for mentioning that point, because I was going to come on to deal with that. We don't accept that it was not established, and briefly, can I just address, therefore, that point? First of all, obviously, Parliament in 1999 had passed what would have become, had it been introduced, 58B, which recognised the existence of litigation funding agreements. So those were in the contemplation of Parliament 7 years earlier. Secondly, we say that the decisions in Arkin and Factortame, whilst they may not be the sort of third-party funders that we're familiar with, so familiar with now, were nevertheless a form of third-party funding. And as it happens, in your bundle at, I think it's page 522, in the bundle at 522, there is the evidence of Susan Dunn, who says, well, she with others established her first fund in 2002.
Is advertising for people who may have a cause of action a claims management service?
Well, as the Better Regulation Task Force report and the explanatory memorandum suggests, one advertises for those who may have a claim in order to then pursue that claim and to put them into a group or to then to refer them on. So at that stage, which is why in answer to my Lord Stevens' question, I said that claims management involves management or control for all or part of the claim. So at that stage, they are putting together the claim.
So your answer is that advertising for people is not itself a claims management service?
No, I say that advertising is... Sorry, I may have misheard that.
No, yes, I thought you were saying that advertising would be a prelude to something that you would call a claims management service.
No,
but am I wrong? You're saying it's actually a claims management service in itself, are you?
Advertising for clients to pursue a claim is that early stage of the management and the control of the claim.
Well, how is advertising managing a claim? In the ordinary sense, in the sense of controlling it. If you advertise, you have no control over a claim at that stage. You may get a client whose claim you may then manage.
Because at that stage, one is inviting the clients to come to you in order to pursue a matter. Now, I accept that is at the very, very beginning of any relationship, and the relationship may not develop. But that is the start of the putting together of the claim. As I mentioned a few moments ago and didn't actually move on to, that when one looks at 656, which is within the memorandum with regard to the scope order, you were taken to paragraph 7.6, and I just want to briefly return to it. Because we do draw attention to the fact that it says in the fifth line down under 7.6, the scope order specifies the activities that will be regulated. The activities are those characteristically provided by claims management companies. So these are all activities that are characteristically provided. None of these, obviously, third-party funding is not anything that's identified anywhere in any of the material as being an activity that is either carried out by claims management companies either occasionally or characteristically. And it then goes on to say, still within 7.6, and have been described in such a way as to ensure that similar services provided outside the area of the claims management industry are not inadvertently regulated as claims management services. So it recognises that there was, at that time, something that might be described as the claims management industry. And we say that that could not, on any common sense reading, apply to independent third-party funders.
What emerges very clearly from 7.6 is the intention of the government, at any rate, well, its understanding that the definition in the Act was wide, as it says, to allow new areas to be brought within the scope of regulation where problems arise, and then to rely on the regulations themselves to give to focus on the areas that prove to be problematical, or indeed to remove areas that had ceased to be problematical. So I mean, the thinking seems to be the Act provides a wide scope so as to enable the government to respond flexibly, and then the regulations are the response, which will be more narrowly focused.
Well, we say that even with the interpretation, which obviously we submit as the correct one, the interpretation arrived at by the CAT and by the Divisional Court, that still remains a very wide definition, but it does not extend beyond activities that may never have been regarded in 2006 as anything to do with claims management services or the claims management industry.
But I mean, you've taken us to this, as I understand it, as an aid to construction of the Act itself. Yes. But the bit that you cited to us is explaining the ambit of the scope order. It's the scope order that is framed to focus on these particular activities. So I'll just read it. The scope order specifies the activities that will be regulated. So the Act could be of any dimension, but obviously wider than the scope order. It's now being said the scope order is specifying the particular activities that will be regulated, and we've seen that's the structure of the 2006 Act. And then it says the activities are those characteristically provided. That's referring to what the scope order is doing, isn't it?
My Lord, we would say no, and the reason why we would say no to that is because it going on to say to ensure that similar services provided outside the area of the claims management industry are not inadvertently regulated as claims management services. So there is a recognition that certain services are regarded as within the scope of the claims management industry.
Right, but this seems to be saying that the way that we're avoiding inadvertently catching other things isn't by focusing on the definition in the main Act, but by focusing the scope order itself on particular areas, which are the areas which are proved problematic. Well, I'm not sure how that helps you meet the arguments against you, that in the context of the 2006 Act, taken as an Act by itself, that the ambit of claims management services is set wide with a view to the regulator then focusing down on particular problem areas, which seems to be reflected in paragraph 7.6, isn't it?
If one just focused on section 4, we would submit that the interpretation put forward on behalf of DAF is so wide that one completely renders the words claims management obsolete. So one has got no concept of management.
Well, that's the potency argument.
That is the potency argument, which to a large extent I'm leaving to my own friend Mr. Thompson.
Right, well.
But
what you rely on here is that there seems to be some concept of the area of the claims management industry there, which you say feeds into the definition of claims management services and would not have been regarded as, in 2006 or now, as including third-party funding.
Yes. I'm conscious of the time. Can I? Sorry,
one matter I want to raise with you before you finish.
Oh, I'm not about to finish. Don't worry.
I can raise it now. No, I know, but perhaps I should just raise this now and give you a chance to deal with it. If we're against you, then I think we would obviously be allowing the appeal. We'd be allowing, I think, the judicial review of the tribunal's decision. So that would be the immediate result would be that the tribunal's decision on the particular procedural issue that was before them would be reversed. The wider concern, obviously, is that the implication of the judgment would be that these agreements are unenforceable. So what then happens? Would the industry have to seek an amendment of the 1990 Act by statutory instrument? Can that be done?
Well, if were you against us, the industry would obviously be faced with Section 58AA, which would rule that third-party funding agreements were damages-based agreements.
Yeah.
Now, the industry may be able to, there are possible get-arounds in relation to that, but obviously my lords would be, and my lady would be declaring what the law has always been. Yeah. And so, so far as funded claims from, I suppose, 2006 are concerned, or perhaps from 2013, funded claims from 2013 are concerned, those that have concluded or those that are ongoing, where there is a third-party funder, would be there would be an unenforceable funding agreement with regard to those claims, and presumably there would be, so far as claimants who had 10, 20, 30, 40% or whatever of their damages paid over to the funder, there would then be arguments about whether they were entitled to recover any of those sums.
Yeah. Yes, I was wondering if there was a Henry VIII clause in perhaps a 2000, perhaps in the 1990 Act that would enable a speedy amendment to be made, and those you represent would want to argue that it had retrospective effect.
Well, I'm not aware. I have to confess I haven't looked to see whether there is such a clause, but I don't think there is. I mean,
I won't take up more time.
No, but clearly, as I said at the beginning, I wouldn't be dealing with the consequences, because that is set out, in particular, in fact, in the interveners' shorter written case, and obviously the consequences would be very substantial indeed. Can I, notwithstanding taking on board comments made before lunch, can I just very quickly deal with the reforms made pursuant to LASPO, which was obviously the introduction of DBAs to wider litigation, as well as other amendments. Those, as you will be aware, were the acceptance of recommendations of the Jackson report, which had recommended both the extension of DBAs and self-regulation of litigation funders. Now, those are, I accept, later legislative provisions. They are, we say, inconsistent with the interpretation put forward by DAF, and apparently it would appear that Lord Justice Jackson and others who made those recommendations and who reported made them in complete ignorance of what is and is said to be a clear and unambiguous application of claims management services to third-party funders.
Would it be assisted by knowing how we can use the Jackson report as an aid to the interpretation of the 2006 Act?
Well, that's why I said I've taken on board the points that were made before lunch, so I don't propose to repeat them, but by way of confirmation. Can I deal, in the light of the time, can I move on and just, I know I said I was going to leave to Mr. Thompson mainly the point about the potency of the terms.
Is one of you going to deal with this Suberi point that seemed to be a slightly different point about...
Mr. Thompson is, I hope, going to deal with that, Ben. Sorry, forgive me.
No, that's an answer to my question.
I talked over you, I do, please forgive me. Yes, Mr. Thompson I think we'll deal with the Zuberi point. Obviously, Zuberi is the only time in which, to any real extent, the DBAs have been considered by the higher courts. I was going to deal just briefly with Delaney, and this is a point in relation to the potency of the term defined. And forgive me a moment. The decision in Delaney is at page 790. Decision of this court, or House Lords. And it concerned the definition of wages and whether a payment in lieu of notice paid by an employer when terminating employment without notice was a payment, was included within the term wages. And one can see the definition of wages at page 796. So as to wages, section 7 of the Act provides, in this part, wages in relation to a worker means any sums payable to the worker by his employer in connection with his employment. If one goes to page 797, you'll see at letter D, the issue is identified, namely the critical question is whether a payment in lieu falls within this wide definition as being a sum payable to an employee in connection with his employment. And if you could scan down to between letters G and H, Lord Brown Wilkinson said, the first inquiry must be whether the language of the Act throws any light on the problem. The words in connection with his employment are very wide. In my judgment, quite wide enough to include a payment in lieu. If one could go to page 799, at letter D, he continued, therefore, on the language of the Act, I find neither anything which cuts down the wide meaning of the words in connection with his employment, nor anything which demonstrates that Parliament intended payments in lieu to fall within the definition of wages. I therefore turn to the way in which the Act would operate if payment in lieu were included in the word wages, and then he goes through how it would operate. Can I, in passing, also refer to what is said at letter E on page 800? I find it impossible to believe that Parliament, in passing this legislation, intended by a side wind to alter the common law rights of employers and workers on the termination of employment. And then carries on, for these reasons, I'm forced to the conclusion that payments in lieu of the fourth category do not fall within the statutory definition of wages. Where then is the dividing line to be drawn? In my judgment, one is thrown back to the basic concept of wages as being payments in respect of the rendering of services during the employment. So it's to exclude all payments in respect of the termination of the contract, save to the extent that such latter payments are expressly included in the definition in section 7.1. So there we had a very wide definition, which it's acknowledged would include, on the face of it, a payment in lieu in those circumstances, where the House of Lords then went back to the basic concept of wages, and we say one can go back to the characteristic claims management services as conducted by the claims management industry.
Well, it's a slightly different point that Lord Brown Wilkinson was making. He was saying that if you did apply the wide definition, in the rest of the Act, then there were going to be interferences with common law rights that Parliament was unlikely to have intended. And as you know, there's a presumption against interferences with common law rights unless the intention to do so is reasonably clear.
Well, in a sense, that's one of the points that I was going to come on to make, which is why I read also at the bottom of the paragraph that came up to letter E, which is that, of course, by the time of the Compensation Act, litigation funding of various forms have been seen as an important part of providing access to justice. And so one had, we say, litigation funders by that time, and yet it is now said that what the common law had recognised, because obviously this was a development from Champty and maintenance and moved quite a way, what the common law was now recognising as being a useful part of providing access to justice was apparently to be done away with by Section 4.
It wasn't being done away with, it was just being brought within the scope of regulation, wasn't it?
Well, it was...
Don't do away with it. It makes it all the more likely they'd want to bring it within the field of potential regulation, should it be thought necessary.
Well, then one might have expected there to be some reference to third-party funding, or one might have expected when LASPO was introduced, for, at the very least, Section 58B, with its potential to come in to regulate third-party funding, one might have expected Section 58B to have been repealed, because now funding was going to be regulated under Section 58AA, because it does form a part of regulating third-party funding if it applies. But there is no reference, no one can point to any single piece of material in either the pre-legislative material and only a passing reference, indeed, even in post-legislation material, to any suggestion that this was ever intended to cover third-party funding, or that that was a mischief that was being addressed in the Act for which which it was intended to address. There is simply...
Isn't that another reason potentially why Section 58B wasn't brought into force? Namely, well, you had the ability to regulate these matters under 58AA.
Well, but at the same time as introducing 58AA and extending it to all civil claims, one is accepting Sir Rupert Jackson's report that there should be a voluntary regulation of third-party funders. So, in our submission, that's...
58AA is it's not neutral as regards things that don't fall within it, unlike Section 4, which doesn't render illegal claims management services which are not brought into regulation. Section 58A does render unenforceable agreements which do not comply with the regulations.
Section 58AA, if a third-party funder is providing claims management services, then the fact that it's included or excluded under any scope order is neither here nor there, because Section 58AA does not refer to regulated claims management services. And so the third-party funder would be caught by Section 58AA regardless of the extent of the scope order.
Yeah, but that's the argument against you, though, because the argument is proceeding by reference to the 2006 Act, which has a different overall objective than, or effect, than the later amendments with Section 58AA. I mean, in a sense, that's the essence of the argument against you. You know, the nub of it is we're looking at the meaning of this term as it came into the world in the 2006 Act, where it had a particular place in the legislative scheme, where to construe it broadly does not create particular problems. It's just an entry point, gateway into possible regulation. And then that same term, but everyone agrees it is the same term, is used with direct regulatory effects through the statute itself. But just pointing that out to us doesn't help us with or as it seems to me, with the interpretation of the term in the 2006 Act. And you accept we're concerned with the interpretation in the 2006 Act.
As imported into the Section 58AA.
Yeah, but you're not suggesting it's changed its meaning, are you? Sorry, I didn't mean to cut across.
We have not. That has not been part of our case now.
But I thought it was part of your case to say that it leads. What we're actually construing is Section 58AA, subsection 7, and if it leads to absurd results, which you say it does, or results that Parliament can't possibly have intended at the time that 58AA was introduced, to, by a side wind, it said, suddenly render all these agreements unenforceable, then what one is looking at is there anything in what's now Section 419A and how that has been treated, and Section 4 of the 2006 Act, which shows that Parliament must have intended that result of Section 58AA.
We would submit that the answer to that is probably the use of the word representative in the regulations that I took you to earlier, both the 2010 and 2013 regulations, that the word person in 58AA should therefore be that the person is really the representative, because that's the only way in which the section combined with the regulations can work.
Or putting it the other way, that the way that the 2013 regulations were drafted shows that these were not regulations with which it was possible for a pure litigation funder to comply. And therefore, if Section 58A means what DAF say it means, then those regulations were incomplete or have accidentally rendered all these agreements unlawful.
Well, we certainly say that the regulations make no sense if one seeks to apply them to a third-party funder. That's the point I think I made before lunch, with regard to, in fact, a point that the lady raised.
What we're asking you about is, all right, so if one concludes from that Parliament did not intend, when incorporating the definition of claims management services, that litigation funding should be, that somebody providing litigation funding should be a person providing claims management services within the meaning of Section 58AA, how do we jump back from that to the meaning of Section 4 of 2006? Well, if you start from 2006 and move forward, which is what is put against you, that's one way of looking at it. But if you start from Section 58AA and move back, what is the basis on which you can move back from the absurdity that you say arises from the point that my Lord Sales pointed out, which is that it doesn't refer only to regulated claims management services, but to all claims management services? Well, how does that assist with the looking again at what it must have meant in 2006.
Well, I think it would have to be whether this would be one of those reasonably rare occasions where the subsequent legislation may fix the proper interpretation, but that hasn't formed part of our written case. But obviously there are authorities on that point where the later legislation deals with the same subject matter. Certainly we would say, and I'm now conscious of over time, certainly we would say that the regulations make no sense if applied to third-party funders. And that would obviously be a difficulty for any funder going forward were this appeal to be allowed. I've gone over my time, so forgive me.
Well, it's Mr. Thompson's forgiveness, I think you require.
Unless there are particular points that I can assist on.
Thank you, Mr. Kelly.
Will you forgive us again for a couple of minutes? Furnish me.
My lords, my lady, I think the one thing that's become clear is that this is quite a complicated topic where an hour can go quite quickly, so I will endeavour to be focused in my submissions, and in that spirit, if I could pick up one or two points that have already emerged, and in particular the one that has just been the subject of debate, and I think was raised by my Lord Stevens before lunch. The relevance of events after 2006, and I think there are three limbs to the answer. One is absurdity in later legislation is relevant where there's ambiguity in earlier legislation, and we say that applies here in the adoption of Section 58A in relation to employment tribunals and more generally in civil litigation in 2013, by which time, of course, Lord Justice Jackson had made his findings, and in 2012 the Association of Litigation Funders Code had just been adopted and approved by Lord Justice Jackson at the end of 2011. So it does appear particularly strange that third-party funding, which had just been approved in a non-statutory form, should suddenly be subject to a statutory regulatory scheme which doesn't mention it some 18 months later. So we would say that there was ambiguity at least. We would actually say that there's no ambiguity. It's not, I think, as Lord Justice Coulson in Zubira said, the draftsman's finest hour, but we would say that in reality the legislation means what we in the Divisional Court say it means. But if there is ambiguity, we would say that the later absurdity is relevant. Secondly, and this is a particularly complicated point in this case, which we've addressed in Section D of our written case, the secondary legislation in this case is fourfold. The secondary legislation in 2006, 2010, 2013, and 2018 in relation to FISMA. And I think my learned friend Mr. Thankey accepted that in each case it's integral secondary legislation and therefore relevant to the interpretation of that specific measure. But I'm not saying that, for example, the 2018 notes or secondary legislation could be used to interpret the 2006 Act. I'd accept that, but it can be used to as it were, interpret its parent act in each case. And then the third point, which I think Lady Rose has raised, is that, and it's relevant to our case in particular, that Section 4189A1 was adopted independently in 2018 on the basis of a further report which had been adopted in 2016 and specific explanatory notes And given the time...
Well, it's not adopted on the basis of the notes. The notes are a separate civil service document which don't even accompany it in Parliament.
I'm sorry, my Lord, I'm moving too quickly. But what I would submit is that the Brady report, which surveyed the claims management sector and led to the transfer of responsibility to the Financial Conduct Authority, is something that certainly can be taken into account, and the explanatory notes can be taken into account for what they're worth. And that's paragraphs 27 to 29 of our written case, and supplementary volume tabs 41 and 97. So that's what we say about relevance of post-2006 events.
Do we have anywhere the equivalent for the scope order made under the Financial Services and Markets Act?
You do.
Been shown me earlier.
You do, my Lord. It was done in a different way, but broadly the same sort of
At some point, can you
exercise.
use a reference? That'd be helpful.
Yes, I think I've given you the explanatory notes, and I'm sure I can
I'd rather
give you
have the actual instrument.
Yes, indeed. The second point, and I think it's a point that's been raised by Lord Leggett in particular, arising from some questioning from Lord Sales in relation to section 4.3b, is that we would accept that section 4.3b doesn't, strictly speaking, relate back to 4.2a, but rather to 4.1. But there's a different technique in 4.1a2, in that it doesn't expand the scope of claims management services. It actually relates to other services. And our point is that unless other services are constrained by the primary legislation, then it would be futile, primary definition, it would be futile to have an expansive definition in 419A2, because other services is obviously a completely unlimited category. So we say it actually assists and is in some ways clearer than the 2006 Act. So we wouldn't accept that 419A2 is actually helpful to Mr. Thankey, and I note that he hasn't exactly put it at the forefront of his case. The third point is a point that my lady...
I didn't quite grasp why you say it's helpful to you that other services specifically includes financial services.
Well, normally, my Lord, other services, normally an inclusive definition expands the scope of what it defines. But here, what it's referring to is other services. And on its face of it, other services is a very wide category, in fact, a completely unlimited category. So the way I say it assists is in the same way that my Lord Sales was putting to Mr. Thankey this morning, is that what it actually shows is that the primary definition, the word claims management services, and in relation to a claim, and insofar as you can take aestum generis note of the word advice, it suggests that there is limitation in the primary definition, because otherwise there'd be no point in the expansion. There'd be no need to expand, because other services is completely general. It would include photocopying, taxi services, anything. So that there would be no point in the secondary legislation unless the primary legislation is tightly confined. And
I think tightly has some limit to it, one might say.
yes, so
Not totally unlimited.
yeah, in my submission, it actually requires there to be a limitation in the primary legislation, because otherwise the secondary definition would be unneeded, would not be needed. So I understood
still leaves
that.
you with financial services staring you in the face.
Well, I think it's...
That funding is a financial service.
Yes, as is insurance, my Lord. But I don't think Mr. Thankey has really faced up to the problems that his approach faces, because it's not only a very wide category of financial services, which on the face of it are caught, but also, and legal representation is perhaps clear enough, but introducing people to one another and making inquiries is a completely unlimited category. I mean, it would include private detectives. I think it's a point we've made in our written case. And introducing people to one another is really a completely unfocused category. And if as Mr. Thankey tells you, the primary definition is simply that it's got to be in relation to a case, then barristers' clerks would introduce people to one another. They'd say, that nice Mr. Thompson can do your case for you. And that would be caught by this legislation as well. in my submission, that's a form of absurdity.
Well, we say that, but it's, we sit here looking at legislation day after day, week after week, and it's very common with framework legislation to have the primary legislation put in very broad terms, and then all the detail appears in the secondary legislation.
Yes, but what is the limitation of the third and fourth examples?
And in that way, you avoid the risk of various problems. And the government avoids the risk of various problems.
The third point, in fact, there was a point I think that Lady Rose raised, the question of varies, that Mr. Thankey, I think before this court and not so much below, says that any absurdity issues can be dealt with by the fact that the regulator or the Secretary of State or Parliament can step in to stop overreach. But in my submission, that's not a complete answer if the scope of the power that's granted is excessively wide. And in my submission, given the sort of examples that were put to Mr. Thankey by the court, or the types of examples that I have suggested and that appear at paragraph 14, 5 and 6 of our written case, this is a case where the varies would be absurdly wide.
I'm sorry for interrupting, but if there's an ambiguity in earlier legislation, then the subsequent legislation may fix the proper interpretation which is to be put upon the earlier.
Yes.
The difficulty, or it might be suggested that the definition at page 641, I think it is, 643, which supersedes section 4.2, is even stronger. And so if there was any ambiguity in section 4.2, then the subsequent legislation, we found on page 643, would resolve that ambiguity.
Yes, I think that's the point that Lord Leggett made in argument this morning,
yes,
and that I was seeking to respond to.
Right.
And the point I'm making is that if we look at page 643, the primary definition is, in this Act, claims management services means advice or other services in relation to the making of a claim. And the word other services is on its face entirely general and doesn't require expansion or clarification, because all services are services, apart from advice, are services other than advice. So there's no need to expand that category, because unless there's some limitation in 419A1 itself, 419A2 is completely redundant. So the point I'm making is that you need to find some term of limitation in 419A1 to give 419A2 any purpose. And so in my submission, what that does is actually reinforce the correctness of the divisional court's finding that there must be, and indeed the tribunals, that there must be implied into 419A1 some limitation. When you ask yourself what that limitation is, the one that the tribunal and the claims and the divisional court came up with is overwhelmingly the correct one, and that in fact Mr. Thankey hasn't come up with any alternative term of limitation.
Well, he doesn't need one.
Well, in my submission he does, because other services is completely wide, and if there isn't any limitation, then 419A2 is redundant.
And you say that that limitation is that it has to be the kind of thing that is claims management services. It has to involve conduct of...
Indeed, and as I understood it, that was the point that Mr. Sales was, my Lord Sales was putting to Mr. Thankey this morning, in that you have to read something into 419A1 or the equivalent in the 2006 Act. And when you say what is that thing, there are basically three clues. There's the word claims management services, and I think Mr. Thankey hasn't suggested any reason why the word management appears in that, and that's the potency argument. And advice is the quintessential activity which is given by lawyers, but also by representatives advising whether to go ahead with the claim or not. And then in relation to the making of a claim, on the face of it, it's a neutral term, but it's at best, it's at least ambiguous as to whether or not making may involve something more than simply bringing the case, but it might also involve conduct of the claim. And so in my submission, in order to give some sensible meaning to 419A2, you need to have some term of limitation, and if the limitation is going to be there, the obvious limitation relates to management of the claim.
I think the exclusion of witnesses must imply that making a claim goes beyond the actual commencement of the proceedings, or indeed the sending of a letter before action or something like that.
Yes, my Lord. I was actually going to come on to another question which emerged after lunch from Lord Leggett about what about advertising for a claim. But if I could, before that, respectfully adopt a comment made this morning by my Lord Stevens about the mischief associated with third-party funding, having already been addressed in 1999 by the provision of Section 58B, as held, as it were, in terrorem by Section 28 of the Access to Justice Act, even though not brought into force. And in this respect, we're going to struggle to get to all these authorities in the time, but in my submission, not only Lord Justice Jackson's report, but also the judgment of the Court of Appeal in Factortame, which addresses both the common law position and the statutory position and the law of Champathy, and the judgment of Zuberi, which I will come to if time permits in a moment, are highly material in understanding how all this developed. And in my submission, the explanation for why Section 58B has not been brought into effect is not because the Compensation Act 2006 was adopted. It's because the common law was not settled in the first 10 years of this century, which was why the matter was put to Lord Justice Jackson. He made specific references and recommendations, both in relation to third-party funding and in relation to contingency fees. The contingency fee recommendations were adopted in a slightly broken-backed way because Parliament decided that the position in relation to employment tribunals was so urgent that they adopted the legislation in its original form in 2009, and the position in relation to civil litigation was only addressed in 2013, where the Court of Appeal in Zuberi analysed the position in great detail by reference to the history of such agreements and the recommendations of Lord Justice Jackson and the parliamentary materials, and came to a clear finding that the reason why the 2013 amendments were made were for the first time to allow such agreements to be entered into by persons conducting civil litigation, so solicitors and barristers. And so that whole history is, in my submission, extremely relevant to my Lord Stevens' observation that the mischief caused by third-party fundings had been provisionally addressed in 1999, was then addressed by the common law over the following 10 years, and was then addressed by the adoption by the legislation in relation to DBAs, which was adopted in relation to Lord Justice Jackson's recommendations, and by the adoption of the ALF Code in 2011, which left the matter subject to voluntary regulation for the following 10 years. And without wishing to overburden the court, in order to get to grips with the whole history of this issue, there is in fact not only the comprehensive analysis of the Court of Appeal in Zuberi concerning DBAs and contingency fees, but also, and in fact it's the same judge, Lord Justice Newey, his analysis of the development of third-party funding in the Chapelgate case, which is at tab 17. And then there's a very useful summary of that whole area of law by Mrs. Justice Knowles in the Akhmedova case. And if I give your lordships the references, Factor Tame is at tab 27, Zubair is at tab 36.
I couldn't have the page number, I'm terribly sorry. Or no.
I'm sorry, Lord, I don't think I'm going to have time to go through these authorities.
No, not sorry. It's okay. 27.
But we don't have the tabs readily to hand.
I'm sorry, my lord.
So
It's
better
okay.
for us.
It's page 1095.
Yes, if I can.
Sorry, not to worry.
Chapelgate is
761.
761, my lord, and Akhmedova is tab 50, which is, someone will tell me,
1866.
1866, and there are comprehensive discussions of this area of law in each case. And then there were three more narrowly focused questions. Again from Lord Stevens, there was a question about why there's reference to experts in the legislation as being excluded. And I can only tell your lordship that that is addressed in the explanatory notes at page 596. And what it appears to have envisaged was that you could, for example, in a personal injury case, go and consult a doctor or a surgeon who might then become an expert. And it was said that such a person, whether an expert or a witness of fact, would not be caught. And I think the concern would there be that such a person might give advice, for example, as what to do with your bad knee or whatever, and therefore apparently be caught by the legislation. And the purpose was to take that person out of the legislation, because if they were going to then act as a witness. So I think that's a bit of a side channel to our main case. In relation to advertising, my Lord Legate put it to my learned friend, Mr. Kirby, asked whether advertising was caught. And I think the answer to that is actually in the secondary legislation, which we summarise at paragraph 1131 of our written case, which is at page 157, I think, my Lord, of the core bundle. It clearly is part of the mischief that claims management companies were perceived to cold call and ambulance chase, to use a loose term. And although you might say that's not a service, it's not really a service to be addressed, it's clear from the secondary legislation that the regulator or the person adopting it considered it was an important part of the mischief, and I don't think the vires of that regulatory power has ever been challenged, even though...
No, the point I was making was it shows that your explanation of what claims management services means won't work, because advertising is not managing a claim, and therefore it supports the argument that the field of claims management services is intended to be extremely broad, enabling Parliament, for example, to target advertising, which wouldn't be caught by your interpretation.
Well, my Lord, I wouldn't accept that pure advertising, if you never actually did anything. But I think the way it's caught is if you are a claims manager and you advertise, then you're caught by the legislation. But in my submission, it wouldn't be simply advertising, if indeed that's a service to somebody to ring them up and say, do you want me to act for you? But it is something that if you are a claims manager, it's caught by the secondary legislation. That was the point I was making. And then there was some questioning about why section 7.1 and 7.6 were mentioned at core bundle pages 655 and 656. In my submission, the relevance of them is that they give a clear statement of the intended mischief. They describe the scope of the activities of claims management companies, and they indeed at 7.6 make the point that it wasn't intended to go beyond the scope of claims management companies. So it both gives a positive and a negative. I agree there's the point that sometimes Parliament has overreach, but in my submission it gives a clear account of what the legislative mischief that was being addressed was, and that the tribunal and the divisional court were both perfectly correct in their understanding of what the intended focus of legislation was.
The point I was putting before on that, which is page 656, is it showing the legislative mischief that the scope order is intended to address. It might be said that, if anything, 7.6 has a tendency against your case because it reflects the argument on the structure of the 2006 Act, which is being put against you, that you have a wide definition of claims management, see the first sentence, wide to allow new areas to be brought within scope. And then the way the practical targeted regulation occurs is at the level of the subordinate legislation. Now, I appreciate things change in a very important way when one moves beyond the 2006 Act and the primary legislation uses this concept directly to affect the enforceability of contracts. But subject to any argument you have about the law changing, the meaning changing from 2006, the 2006 Act is setting out a regulatory framework. It's not imposing direct effects itself.
No, I understand that point that Mr. Thankey's made at some length. And insofar as it goes, it's a good point, subject to the point I made about varies, and that this is not a sort of uncharted area.
But you were seeking
the point I'm making is the first sentence, or first two sentences of paragraph 7.1, which describes the focus of the intended legislation, and then in 7.6 there's a reference to the definition of claims management services in the Act is wide, and then further down it says the scope order specifies the activities that will be regulated. And then I'd agree there could be a degree of ambiguity, but it says the activities are those characteristically provided by claims management companies and have been described in such a way as to ensure that similar services provided outside the area of claims management industry are not inadvertently regulated as claims management services. So in my submission...
Is this how you would put your case, that if some short time after the 2006 Act came in, the Secretary of State had purported using this power to regulate standalone litigation funding, there would have been a big row as to whether that was intra vires or ultra vires, the power that had been conferred, because it's not clear whether it would have extended to that.
Yes.
That looking back at how Parliament seems to have used this definition more recently, one might say, well, if that had been fought out in 2007, it would have been held to be ultra vires, because it's not within what Parliament regarded as the potential scope of regulated activity in that time.
Yes, well, I think I could probably put it possibly even higher than that had that even been a possibility, that the government would been likely, put it no higher than that, to been advised that they didn't have varies for it. And that might explain why nobody, including Lord Justice Jackson, who knows as much about this as anybody, not only didn't consider it, but specifically addressed it in a separate section of his review, which was then acted on by the government in 2013. So, and by the industry in their code in 2011, and why Lord Justice Newey, who considered these matters in great detail, both in relation to damages-based agreements and litigation funding, treated them as insulated compartments and didn't in any way think that one might prejudice the other. I mean, I'm conscious of the time, and I've been somewhat jumping around out of the route I was going to take, but that's fine, because I think we've addressed a number of issues.
I do apologise, Mr. Thompson, for taking out your way again.
Not at all.
If you go to page 652, and just so I absolutely fully understand your reply, appreciate it, which is the point that my Lord Legate has raised. A is advertising for, or otherwise seeking out, persons who may have a cause of action. And how does the actual activity of advertising or seeking out come within the concept of claims management?
Well, I don't think I can do much better than to point out that that was the focus as understood by the government in paragraph 7.1 of this same document, that
It's not managing a claim, is it? It's not managing.
it's not yet managing, it's true. It's you're engaged in the business of managing claims and you're touting for business. I think there is in fact a European Union case called Alpine Investments where this very same question arose about cold calling for services between, I think, the Netherlands and the United Kingdom, and whether that was caught by the rules on the free movement of services, and it was found that it was, so that effectively touting for business was treated as part of the business. And that's certainly how the legislator has applied here, and as I've said, I don't think it's been challenged. But in my submission, even if that's a questionable extension of the legislation, with respect to my Lord Legate, I don't think it casts all that much light on the issue that we're concerned with here, which is the regulation of third-party funding, because I think it's probably true that advertising, being one of the things that was most generally criticised in relation to the claims management industry, is probably something that would have been difficult to challenge, and it has in fact been at the forefront of each of the items of secondary legislation, both in 2006 and in 2018.
What about arranging ATE insurance?
I'm sorry, Maud?
What about arranging ATE insurance? Suppose you conduct a business where you find ATE insurance for litigants and make a huge profit as an intermediary. Is that within claims management services or not?
Is that
within the definition on your case or not? If you're not involved in actually controlling the conduct of the claim, but your business is finding ATE insurance for people who wish to bring claims. Is that a claims management service?
You mean if without any element, if that's all you do?
Yes.
Well, I must say I had thought that I don't think it's. I think it had been thought both by the Divisional Court and by the Tribunal that it was an improbable extension of the legislation to involve loans by banks, and in my submission, extending it to insurance of claims.
That would be regulated activity anyway under FSMA.
Yeah, it seems to me it's a yet further improbable extension. I don't think your Lordship would be surprised that the financial commitments that are made, particularly in relation to adverse costs in these collective claims, are substantial and quite often supported by consortia. And I think if it was suggested that all of them are potentially claims management companies, that would be a surprise to everybody. And I've given a number of other examples, and transcription and bundling services would be another surprising example. Barristers' clerks would be another surprising one. And I think private investigators and forensic accountants would be another surprising one. So
well, I only mention that because in paragraph 7.1 of the explanatory note, sale of after the event insurance is picked out as one of the ways that claims management businesses make money.
Yes, indeed.
So I thought it might have been a targeted activity.
Well, my Lord, I don't want to have any misunderstanding. In my submission, it's perfectly clear why financial services were included, it's because, and not surprisingly, one of the, and probably the chief commercial attraction of entering into claims management businesses is to make money. And one of the ways of making money was to enter into financial arrangements which were widely criticised. And that's, if you look, my lord, at the Better Regulation Task Force document, you'll see that that was a core element of the concern. So,
well, it's just an example, though, of how claims management can't mean just managing in the sense of controlling the conduct of claims.
Yes, I mean, I just don't have time to go to the Factortame case, but you'll have seen in our written case that a similar argument was raised in Factortame, that litigation services in section 119 of the 1990 Act is described as any service provided by somebody who conducts litigation. And you might say that solicitors do all sorts of things, and so anybody who performs any of those services is therefore caught by the Court and Legal Services Act. So the example in that case was an accountancy firm that was providing litigation support, and they said, oh, that's the sort of thing a solicitor might have done. And so there are all sorts of things that claims management companies might do. But that's in a way precisely my point, that the legislation would be ridiculous if everything that a claims management company might do and might be criticised is automatically caught. So I think your example of the after the event insurers, I don't know whether your lordship's putting to me that all insurers are caught by this legislation because claims managers might do it. And my point is the reverse, that just because claims managers do something which causes problems doesn't mean that everybody who does that thing is automatically caught by this legislation. Otherwise it would become ridiculously wide. And in my submission, that is the implication of Mr. Thankey's case, because he has nothing to constrain the scope of the legislation apart from it being in relation to a claim, which I think at some points he says, oh, well, it raises a similar risk to claims management companies, or he has a sufficient nexus with the claim, or it's routine. But in my submission, if he's criticising the divisional court's position as circular or vague, then his own suggested limitations are open to at least the same criticism, and probably more so, in that they appear to have no clear rationale at all. And that's at section 85, paragraph 85D of his written case, or paragraph 98, where he distinguished between a core service and a penumbral service, but he doesn't appear to have any clear criteria in how you distinguish from one and the other. And in my submission, the obvious ways to limit the class are by the reference to claims management itself, as described in the explanatory notes, by the parallel reference to advice in the legislation, or by the words in relation to the making of a claim, and not reading it as just a sort of indiscriminate something to do with litigation,
so if
which I think is all.
If you're doing the core things, then the penumbral things that you do are also caught. But if you're only doing the penumbral things, then they're not caught.
Exactly. Yeah. So it's, and that was pretty much the way that the Court of Appeal in Factortame, they said, well, all sorts of people could do all sorts of things in relation to litigation, what they called ancillary to litigation, but that didn't mean that they were all caught by the Courts and Legal Services Act. And I think your lordship shouldn't forget that in the end, you are considering the scope of the Court and Legal Services Act 1998, and it's quite clear that the focus of that is the regulation of legal activities, and that claims management services are somewhat peripheral to the core focus of the legislation, and that's an important aspect of this. And I'm again conscious of the time, but I think I need to address the point that my Lord Reid put to Mr. Kirby about the implications of this argument, because while the general position in relation to civil litigation is already quite drastic, because whereas everybody, including the Court of Appeal, has been assuming for the last 20 years that third-party litigation funding is governed by the common law and the Association of Litigation Funding Code, and cases such as Excalibur or Chapelgate have considered this and looked at the whole history of the matter over decades. It's now being said that statutory regulation was introduced, as it were, by mistake in 2013, but the position is actually more acute in this jurisdiction that we're concerned with, collective opt-out claims, where I know my Lord Legate and Lord Sales sat on the Merrick's case, and the implications there are in fact quite drastic, because the possibility of funding opt-out collective claims could, by this curious sidewind, be really radically changed, because funders would be actually banned from entering into damages-based agreements by a sidewind which was apparently adopted without consideration by anybody, first of all in 2013, and then in 2015, and then apparently in 2018. And that would be a particularly strange outcome, given that the Competition Appeal Tribunal, and in particular Mr. Justice Roth, who heard both the Merricks and the case in this case, was heavily involved in the preparations for this regime. And he referred in his first Merricks judgment to the fact that litigation funding was specifically understood as an important underpinning of this regime, and that the banning of DBAs was a quite different question, and he cited statements in Parliament to that effect in his Merricks judgment. And likewise in this judgment that we're concerned with here at paragraph 65 and 66, he makes exactly the same point, that litigation funding is critical to this regime. And so it would be a case where I think both Lord Brown-Wilkinson in Delaney and Lord Justice Henderson in this case described the effect of Mr. Thankey's case in this case as creating by a sidewind an effect that nobody could have anticipated. That's paragraph 89 of Lord Justice Henderson's judgment in this case, and the reference in Delaney, I think your lordships were taken to it. I'll find it in a moment. It's at page 800, at tab 18 of Primary Volumes 2, and we would say that it is well within the same principle, but it is impossible to believe that Parliament in 2013, 2015 and 2018 adopted legislation per incuriam and in the face of completely inconsistent recommendations from Lord Justice Jackson, and that this was not considered by anybody as a possible implication, was contrary to the basis on which the legislation had been adopted in Parliament as a means of improving access to justice, and that this fact had escaped not only the Court of Appeal in considering this issue over 20 years, but also Lord Justice Jackson in considering the matter in 2009 and 2010, but also completely escaped Parliament and the Competition Appeal Tribunal in assessing this regime.
This is one of several cases we've heard recently where if the appeal is upheld, the implication will be that the Court of Appeal have been banking up the wrong tree, as it were, for decades. But, it happens. My questions were really directed towards finding out if there was a practical way of of dealing with the fallout, as it were, without, so as to minimise the disruption that might be caused?
My Lord, well, I think it's implicit, not only in relation to civil litigation, as I think Mr. Kirby has already indicated, that there would be, to put it at mildest, very substantial disruption and uncertainty. In relation to the Competition Appeal Tribunal regime for opt-out claims, I think there would be consternation that a regime that had been in place now for 8 years was suddenly effectively put back to square one in terms of the basis on which it was to operate.
Are they all damages-based agreements?
Well, for example, I think I give the example in Merrick's that is, well, that is, in the short amount of time I have left, I should address the point, although Mr. Thankey's indicated that he was proposing to rely on his written argument, that there is a question, to put it at its lowest.
No, I'm not talking about that. I'm wondering whether it's only damages-based agreements by litigation funders which are in peril here.
Yes.
But if a litigation funder lends money on some other basis, then that would not be affected. But are you saying that they are all damages-based agreements, basically?
I think Mr. Kirby has given
Putting on one side your point about whether it is actually a damages-based.
Yes, but there are several points there. I mean, and I think it is worth spending a moment on that question as to what is a damages-based agreement in relation to an opt-out collective claim. And my basic submission being that DBAs, as interpreted in my submission correctly in Zuberi, are focused in the context of civil litigation on legal representatives, barristers and solicitors, that an obvious example of a DBA would be for me to say that I will only act on a case, an opt-out case, if I get 1% of any receipts. And there's a very obvious public policy objection to that, in that that could be an astronomical amount of money and might be thought to be contrary to fairly basic principles in relation to legal representatives, and likewise for solicitors' firms. And that contrasts with, for example, the case in Zuberi, where I think the lawyers in that case were entitled to 12% of the takings. But the position under the Competition Act in relation to third-party funders, were they to be in principle caught, would be quite complicated, because there's a provision which means that recovery of costs and the funder's fee under the competition regime is effectively subject to the control of the Competition Appeal Tribunal, and that's section 47C 5 and 6. And so it's a question as to how that regime operates and whether or not a third-party funder subject to the regulation of the tribunal, who only gets a potential recovery after all the people who've claimed claim, whether that is a DBA as a matter of substance.
So with opt-out proceedings, the damages are assessed and paid for the class as a whole, yes, but there might be a surplus once everybody, yes, actually puts in their claim, and this is one of the things that's dealt with in the course of the certification process. And you're saying that in some of these DBAs, it's only once everybody who can make a claim has been paid their damages that you get your percentage.
Yes, and so there's a question as to whether that fits the definition of DBAs for a different reason, because I think those who were sat on the Merrick's case will recall some astronomical figures being bandied around, but to take a round figure, supposing £100 million was awarded in aggregate, in a consumer case, but the consumers who came forward only claimed 50 million, then there would still be 50 million left over, and it would then be subject to the control of the tribunal what proportion was given in terms of costs and the litigation funder's fee. And so there is a question as to whether or not litigation funding in those circumstances is actually DBA at all, because the claimant gets his entire claim, and those claimants who don't come forward don't get anything, but that's not the funder's fault. And then it's a matter of discretion for the tribunal how much the funder gets. And that's certainly not a conventional DBA as a matter of substance, quite apart from the question of whether there was any intention for third-party funders to be caught by this regime at all. So my primary submission is, when you look at it in the round and the history going back to 2000 and the recommendations of Lord Justice Jackson, it's perfectly apparent that third-party funders were no part of this, and it's perfectly possible to construe the legislation in a different way. But even if it is, we certainly wouldn't accept that opt-out agreements are necessarily caught for the reasons I've just given. So it is actually quite a complicated question to answer Lord Reed's very pertinent question about what the implications would be for the funding industry, both generally and in the context of large-scale competition damages actions.
Could the Secretary of State exempt all existing agreements? Listings or describing them?
I don't think the Secretary of State's represented here, but I obviously can't speak on his behalf, and I think...
Is there any reason why you... Well, it's not a question for you, it's a question for the I suppose.
Yes, I mean, I think we're then getting into the area of the Association of Litigation Funders intervention, and while I fully accept the point that my Lord Reed makes as a general proposition, in my submission this is a case which raises quite extreme difficulties, both of interpretation and of policy, because of the way in which the different strands of litigation funding or legal services representation have developed over 20 years. And my primary submission remains that when one looks carefully at the definitions, you find that, contrary to the normal position where a secondary definition expands the scope of the primary definition, and one looks at the primary definition in neutral terms, given the focus of the secondary definition in this case, which, as my Lord Legate pointed out this morning, in relation to section 43B is actually, 43A is focused on the general words provision of services, not on claims management services at all. And 419A2 is focused on the words other services. In my submission on this particular set of facts and this particular legislative technique, the secondary legislation actually reinforces the need for words of limitation to be read into section 419A1 and section 42B. And if one is in the game of looking for words of limitation, then in my submission, the points that were being made to Mr. Thankey by Lord Sales this morning are very pertinent. Where do you find the words of limitation? You find them in the word management, which has been given no meaning at all by DAF, and by the use of the word advice as being the one sufficient condition for there to be claims management services, albeit that the legislator accepts that advice isn't necessary in all cases. And I think Mr. Kirby has explained to you why one of the models for claims management was to gather in cases and then to accept a referral fee, particularly in relation to civil litigation, which a claims management firm is not entitled to conduct, and that therefore there wouldn't necessarily be advice in such cases. But in my submission, the basic position remains that the way to make good sense of this legislation and the legislative history and the way that a restriction was introduced in 2013, which on the face of it is completely inconsistent with the recommendations of Lord Justice Jackson and the adoption of the ALF Code in 2011, is precisely the way in which the Tribunal and the Divisional Court made sense of it in their judgments, by using the potency of the term claims management, and I would add the eustem generis principle in relation to advice, and say it's not just anybody who provides any service that a claims management company might provide, or anybody who falls within the scope of one of the 4 definitions that's called, that makes them a claims management company. And although I don't think it's received much traction at this hearing, I would urge the court to consider carefully the 3rd and 4th examples, introducing people and making inquiries, and think whether that really makes any sense to have it as an unlimited category, or whether it only makes sense if you read it in conjunction with the explanatory notes as being referrals made by claims management companies and inquiries made by claims management companies. Otherwise, you set off on a raft of completely uncertain scope. And for that matter, it doesn't make any sense of other services or provision of services, because they are completely unlimited. They could be absolutely anything, and there is no limitation there at all. So in my submission, the primary limitation must have a term of restriction if this legislation is made to make any sense. I've basically done this freestyle, and so I apologise if I haven't covered all the points, but I'm very happy to answer any other questions that your lordships may have.
I wonder whether you could just say in a nutshell, you said that DBAs, that the Zuberi case said that DBAs, as far as they are in civil litigation, focused on legal representatives. I wasn't clear from reading your written submissions whether how you're putting this. Are you saying this is a kind of a knockout point, that actually Zuberi says that beyond that, when you're talking about claims management services in civil litigation, you're only talking about claims management services provided by solicitors and advocates, so that this doesn't you don't get to the question of claims management service providers who are not within those categories when you're looking at VA.
Well, my lord, my lady, the point in Zuberi was about the termination provisions under the 2013 regulations, and the fact that the termination provisions in relation to civil litigation generally were apparently less onerous than the termination provisions in relation to employment tribunals, where claims management companies, as Mr. Kirby has explained, were entitled to operate. And so the point made in Zuberi was that the entire objective of the 2013 amendments and the 2013 regulations was to allow lawyers to enter into DBAs, and that the reason why a more lenient approach was adopted to general litigation as against actions in the employment tribunal was that claims management companies weren't entitled to conduct civil litigation. And so the point I'm making is that that gives powerful support, which fits very well with the approach of the Court of Appeal in Factortame, and indeed with the legislative focus of the 1990 Act, that the purpose of Section 58AA as amended was first of all to allow, but only on the regulated terms, solicitors and barristers effectively to enter into DBAs. And we say that fits extremely poorly with the suggestion that out of nowhere, without any consultation, it was suddenly intended to regulate third-party funding.
Suppose in section 58AA, when it defines a damages-based agreement as an agreement between a person providing advocacy services, litigation services or claims management services and the recipient, supposing it had said, included the word regulated before claims management services, would there in that situation have been a problem for third-party funders?
I'm not sure what's being put to me. I mean, it's difficult to rewrite legislation on the hoof.
Well, I was just seeing if, actually, what I had in mind was whether that would be a quick fix for the problem.
Well, I mean, another way would be, and I think that would reflect the statutory intention, would put brackets in the Employment Tribunal, Claims Management Services, because, as I think Mr. Kirby indicated, the reason why Claims Management Services were included at all was because they're entitled to conduct cases in the Employment Tribunal. But the reasoning of the Court of Appeal was that you could have a more relaxed approach to regulation of civil litigation because the only people who were allowed to do it were effectively solicitors and barristers who were already subject to regulation. And so the point I'm making is that the 2013 amendment, very far from making a radical change to the common law inconsistent with the recommendations of Lord Justice Jackson and the steps taken to implement them, had a very narrow focus, and that's what the Court of Appeal rightly found in Zuberi. So that's the point I'm making by reference to Zuberi, and there's extensive reference to Lord Justice Jackson and parliamentary materials in support of the approach that the Court of Appeal took. So in my submission, it can't be dismissed lightly as where they've made a mistake, because the issue wasn't even raised. It wasn't a twinkle in anyone's eye. It was this.
The issue's been recognised for 9 years. I mean, it was first raised in an article in the Cambridge Law Journal in 2014. It doesn't come out of nowhere.
As a point of construction, my lord, I accept that, but all I'm saying is that these two strands have been fully debated and acted on. I think Mr. Thankey at one point raised the issue of legal certainty, and in my submission there is an issue for your lordships as to whether it would actually be compatible with the principle of legal certainty for a regime that had been operating in this way for so long under the supervision of the courts and of Parliament, and where Parliament itself had acted in 2018, and what must be assumed in full knowledge of the state of the law, to suddenly say that that was a complete misapprehension, and whether that's actually compatible with the principle of legal certainty for your lordships to change things at this stage.
But we have to construe the Act. The principle of legal certainty as it applies to us is that we construe the Act properly.
Indeed, my lord.
And I'm not sure that even if policy has developed subsequently on the basis of a misapprehension as to the proper meaning of the Act, that's something that we can take into account.
I think that's why I came to the point first about the question about what is the right temporal lens to look through. And in my submission, given that this was legislation that was adopted and then readopted in 2018, it's perfectly proper for you to take into account the full sweep of things that had happened between 2006 and 2018 and the recommendations of the Brady Report as to what the mischief was and why the legislation was changed in 2018. In my submission, you can't. I know Mr. Thankey likes to keep everything nice and neat and back in 2006, but in my submission, that's not real in 2023, given what's happened since then.
But in 2018, it was still serving its purpose, the definition of claims management services in the Financial Services and Markets Act, wasn't it, for the same as the original purpose, which is to provide an enabling power under which regulation takes place.
But it was.
You haven't yet given us the reference to the scope order for that, which, if you can, it would be useful to have. But
Yes.
that regime is still continuing.
No, I appreciate in relation to claims management, but in relation to the matters with which we're concerned, there was a drastic change.
Well, that's what, but that makes it harder to say that the meaning has changed because of now it's been interpreted by Parliament for this separate purpose, when the original purpose is still continuing in parallel.
I think the point I'm making is
2.9 is the claims management order.
Well, obviously you have to have an opportunity to reply to the question put, but I also need you to be brief because we have to give Mr. Thankey time to reply.
Indeed, my Lord. I was simply going to say that the point I'm making relates to the wording that was used in 4191 and 2, which obviously could have been changed in the light of the state of the common law and, for example, the ALF Code, the adoption of Section 58AA in its original, and that Parliament could and should have been aware of all those facts, and that if there was an intention to catch third-party funding or not to catch it, that legislation could have been amended or changed at that point. And so, in my submission, it's perfectly proper to look at what Parliament could or should have known in 2018. That's the only point I'm making. So, I'm sorry it's been a bit of a disparate gallop, but I hope I've got some points across, my Lord.
Not at all. We've absorbed the points you were making, and we have your written case as well.
I'm grateful.
Thank you very much indeed, Mr. Thompson.
I can't absorb it unless Ms Ayling wants to tell you herself.
Yes, Ms Ayling.
Well, I'm happy to do that one. I think the other reference that's relevant is tab 47, the Financial Services and Markets Act 2000, Claims Management Activities Order 2018, which it should be at page 1702, but something's gone awry, and what's there is not what should be there, and we will undertake to get that to you as soon as possible after the hearing.
Thank you very much.
Financial promotion order rather than the regulated activities order.
Yes, exactly.
The only other point I should make is that the complete 2006 Act, I think, is not in the papers, but is on its way. I'm grateful.
Thank you. Yes, of course, Ms. And if you need to go on for a few minutes after 4 o'clock, that's all right.
Can I just deal briefly with the question of subsequent legislation? It's not in the bundle, but if I try and answer Lord Leggett's question more precisely. Relevant, I think, the leading authorities, in the case of Fitch, and in our recommendations, it's 1985 Chancery 1. The relevant passages are around page 15. We can endeavour to pass a copy to you, Richard.
And in a nutshell, that says what?
In a nutshell, one can have regard to later legislation where the earlier legislation is ambiguous, and for these purposes, the earlier legislation must be open to two perfectly clear and plain instructions, and fairly and equally open to diverse meanings, and the earlier legislation should be part of the same scheme.
And can I just be clear, are you relying on that, or are you just telling us this to answer my Lord's question?
Properly, but in relation to Section 419 of FISMA, for relevant purposes, we would say that is part of the same scheme. which information of claims management companies. And so far as we have been able to discern from the background material to the introduction in 2018, there's nothing in the background material which indicates that the meaning of claims management services was intended to change materially.
Again, sorry, I just want to be clear in my own mind. Are you saying that there's something? I understand that you're saying Section 419A, in pari materia, potentially relevant to interpretation of Section 4 of the 2006 Act. Are you saying that you get something out of Section 419A that you don't get out of?
I've never put it on that basis before. We haven't discerned a distinction which assists us. I can see from what my Lord Nugget said, it is somewhat clearer in terms of what is called by services, but it would be opportunistic of me, having developed a case on the definition of 2006, to say there is something radically different. But to the extent it clarifies, we say it, if I can use the phrase confirming, it is consistent with our interpretation of 2006 as far as it goes.
Right, thank you very much.
But the court has seen in the which to put our case, which is further based on the construction of the 2006 Act. The next point was that in relation to the various regulations that we referred to, we would not say that the 2010-2013 regulations, the DBA regulations, are part of the same scheme as the 2006 Compensation Act. They are not CDALIA orders or regulations passed under the same Act.
But doesn't the fact that Parliament has incorporated that definition make them part of the same?
No, Parliament has incorporated the definition of the 2006 Act for one specific purpose and one specific purpose only, which is to read across the meaning of the definition of claims management services in the 2006 Act. Parliament does that all the time, but it doesn't make any cross-reference. It doesn't bring two acts which use a cross-reference within the same scheme.
When I raised the principle about resolving ambiguity, the sort of argument I had in mind was that it might be argued, although I don't think it has been put this way, that the Competition Act, let's say, when using the definition of claims management services for the purpose of in relation to opt-out proceedings, can't have envisaged that that would include third-party funding agreements, and that if there were prior ambiguity, that could be relied on to favour the case against you, as for the meaning of what claims management services is.
Yes, I see that in relation to the Competition Act. In our submission, that will be pushing the concept too far in the present circumstances. My lords, my lady, the next point I just wanted to address was the only definition we've been given in relation to claims management services, free from any other definition, is Mr. Kirby's, which is managing or controlling a claim for whole or part of the duration of a claim. And there are several problems with that approach. I don't want to repeat myself, or at least not too much, but it underlines a point I made in opening, which is that, for example, the scope order at 652, we talked about advertising, and one has to contemplate the case of a completely unlucky book builder whose advertising is completely unsuccessful. But plainly, he has no control over any claim because no claim eventuates. But what he would still fall squarely within the concept of the scope order, and perhaps more pertinently because it emerges from the scope order itself. If one looks at the concept of referrals in subsection 2c, subparagraph 2c, referring details of a claim or claimant as or a cause of action or potential claim to another person, including a person having the right to conduct litigation. So implicit in the express terms of that is the concept that someone else, the person to whom you are referring, is the person who is managing or controlling the claim. Referring is a narrow concept as used there, and simply does not fall within, if one were to read down the scope order just as the Enabling Act, to managing or controlling a claim, this doesn't work. So that limitation, we say, is a bad one. Then Delaney, I don't want to take too long on this.
Incidentally, I've got the Finch case in front of me. It's Lord Justice Oliver, page 15, and he refers to a couple of earlier cases in the House of Lords and derives from the proposition that it's not enough to show that there are two arguable constructions. One has to go further and show that they're both equally tenable, and there are no indications in the Act favouring one rather than the other.
Indeed, my Lord. I didn't want to spend too long on Delaney. At page 790, but really the short point is if we go to page 800, Lord Brown-Wilkinson accepts our punchline, as it were, in terms of construing section 4. Is he talks about how the Act would be unworkable if payments in lieu were included at pages 799 through to page 800E. So for these reasons, I'm forced to the conclusion that payments in lieu of the fourth category do not fall within the statutory definition of wages. Where then is the dividing line to be drawn? In my judgment, one is thrown back to the basic concept of wages as being payments in respect of the rendering of services during the employment, that exclude all payments in respect of the termination of the contract. And then this, save to the extent that such latter payments are expressly included in the definition in section 7.1. So he was making clear that he'd be bound by the definition if it did include, and it doesn't, payments in lieu, if they were within the definition in 7.1 of the Act. His conclusion is that they are not. So it's entirely consistent with the submissions we made in relation to Phillips, and not inconsistent with it.
I mean, I think you'd be entitled also to say that in that case, he was able to have recourse to an accepted concept. He talks about the basic concept of wages being payments in respect of rendering services.
Exactly.
Whereas if you've made the point here, there is no basic concept.
Yes. If I'd had longer to deal with this case, both limbs of Phillips are satisfied, because he does say there is consensus on the core elements and also the limits of wages in agreement with the Court of Appeal below. So wages had a greater potency than would otherwise be available. Give me a moment. The question of cutting down common law rights, we say that's a bad point. The presumption against changes to common law is framed by reference to abolition, displacement or modification of common law rules. It's Bennion at 1627. But section 4 of the Act does not seek to abolish, displace or modify any common law rules. The doctrines of championship and maintenance are left unaffected by the enabling power in section 4 or the wider regulatory regime in part 2 of the 2006 Act. By way of example, a sham agreement would still be prohibited as such, irrespective of the regime in Part 2 of the 2006 Act. Equally, the provision of litigation funding via non-sham agreements may be subject to regulation under Part 2, but that would not affect the common law rule on shampity in any way. That's our short answer to that point. In relation to the 2013 DBA regulations, no party has ever argued that it cannot comply with no funder has argued that it cannot comply with the 2013 DBA regulations. What the ALF said, this is paragraph 33.4b of its written submissions at page, I think, 232. It simply says renegotiation would be highly fact sensitive on a case-by-case basis. My lord, my lady, I think that's all I had by way of reply points, unless there are any other questions that the court has.
I think not. Thank you very much, Mr. Fenke. Well, we're very grateful to all counsel for their assistance. Legally, this is an intriguing problem, and we appreciate it has significant practical consequences as well. We'll consider the submissions and we'll let you have our judgment as soon as we can.